Commissioner Kerner,
Here.
Commissioner Oglesby,
Here.
Commissioner Phillipson,
Here.
Commissioner Rogers,
Here.
Commissioner Stewart,
Here.
Commissioner Webb.
Here.
We have a quorum present.
Thank you. If everyone could please stand for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I have a few housekeeping announcements. The first DCA graciously let us use their facilities, and we appreciate their being able to use this space in the courthouse. At this time, please silence all your cell phones or put them in the off setting. This meeting is being live streamed, so I ask anyone addressing the commission, please make sure to speak up and speak in the long microphone at the podium so you can be heard and so our broadcast audio and recording equipment can pick up your comments. To my fellow commissioners, please speak up and into the long microphones on the dais so your comments and debate can be heard. Members, I ask that you be as brief and concise as possible in your questions and comments with the number of items on the agenda today. Pursuant to Section 286.0114 of the Florida statutes, members of the public can have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you wish to be heard on a matter, please fill out a speaker card and give it to Ms. Fulford, who has her hand up. Before moving into the approval of the minutes, we have some additional housekeeping matters. Joining us this morning for their first meeting is Commissioner Marty Kerner and Commissioner Joshua Webb, who were recently appointed by the Senate President Alberton. We welcome you to the Commission on Ethics. Would either of you like to say anything at this time?
No, but thank you. It's a pleasure to serve and I'm excited about being here. Thank you.
Just thank you and good morning.
And at this time, we also would like to acknowledge and thank Commissioner Stewart and Commissioner Lyle for their contributions to the commissions as the prior Senate appointees. Moving to the approval of our minutes from the public session on June 5th, 2026. Do I have a motion for approval of the minutes?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
All those opposed? The ayes have it. The minutes are approved. Next is item 4 on our agenda, the consideration of final action. This first item on the agenda is the pre-probable cause joint stipulation and complaint number 23-255, N. Ray Lynn Stoner. After considering all the materials and the presentations of the parties, the commission may vote to approve or to reject a stipulation. If the pre-probable cause stipulation is rejected, we will immediately proceed a probable cause hearing in this matter. Complainants have the right to respond in writing to proposed stipulations. The complainant in this matter did not file a response. Will the parties or their counsel please identify themselves for the record?
Mr. Chair, I understand that attorney Matt Asheville is on display.
Commissioner. Well, why don't, that's still on its way. We'll table this and move to the next item on the agenda and come back to it. When you see him, will you flag for me? Next for consideration is a pre-probable cause stipulation and complaint number 25-304, N. Ray Jennifer Leota. The complainant did not file a response to this stipulation. If the commission rejects this stipulation, we will immediately proceed with a probable cause hearing in this matter. Will the parties or their counsel please identify themselves for their record?
Melody Hadley, Commission Advocate.
Mark Heron on behalf of Jennifer Leota.
Thank you. Are there any members of the commission who need to make a disclosure regarding this case? If so, please state that for the record at this time. Seeing none, Ms. Hadley, you are recognized to present the stipulation.
Well, at this time, I bring before you a pre-probable cause stipulation. Respondent had an employment and/or contractual relationship with Velato Incorporated and Modern Aero. which was subject to the regulation of and/or doing business with her agency. We ask the commission to accept the respondent's stipulation that she violated 2 counts of section 112.3137 and impose a total civil penalty of $2,000 and dismiss allegations 3, 4, and 5.
Thank you. Do any of the commissioners have any questions for Ms. Hadley? Seeing none, Mr. Herron, you're recognized.
On behalf of Ms. Liotta, we would urge the commission to adopt the joint stipulation.
Do any commissioners have any questions for Mr. Herron? Seeing none, we'll move into discussion and debate. Any members wishing to have any discussion or debate on the proposed stipulation?
Commissioner Phillipson, I just wanted to flag something that probably goes back to the disclosure matter. I'm not sure whether it's related, but the St. John's Board of County Commissioners is a former client of my law firm, and I just wanted to state that for the record.
Thank you. So recognized, and it's marked on the record. Anything further on question and debate? Seeing none, I'll entertain a motion for adoption of the stipulation.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
All those opposed? The stipulation is adopted. Thank you, Mr. Herron. Thank you, Ms. Hadley.
Mr. Chair, Mr. Hatfield.
Morning, Matthew Hatfield, appearing on behalf of Vera Lynn Stoner.
Thank you, Mr. Hatfield. Just so we have it clean for the record, I'll reiterate, this is the pre-probable cause joint stipulation in complaint number 23-255, N. Ray Lynn Stoner. After considering all the materials and the presentations of the parties, the commissions may vote to approve or to reject the stipulation. If the pre-probable cause stipulation is rejected, we will immediately proceed to a probable cause hearing in this matter. Complainants have the right to respond in writing to proposed stipulations. The complainant in this matter did not file a response. Will the parties or their counsel please identify themselves for the record? Ms. Hadley?
Melody Hadley, Commission Advocate.
And Mr. Hatfield again for the record.
And Matthew Hatfield.
Thank you. Are there any members of the commission who need to make a disclosure regarding this case? If so, please state for the record at this time. Seeing none, Ms. Hadley, you are recognized.
At this time, I bring before you a pre-probable cause stipulation. Respondent used her public position and/or public resources to secure a benefit, privilege, or exemption for Christopher Longsworth and/or Strata Group in a manner that was inconsistent with the proper performance of her public duties. A related criminal proceeding resulted in a withholding of adjudication and a period of probation. We ask the commission to accept the respondent's stipulation that she violated section 112.3136 and impose a total civil penalty of $2,500 with public censure and reprimand.
Thank you. Any questions for Ms. Hadley? Seeing none, Mr. Hatfield, you're recognized.
On behalf of Ms. Stoner, we urge the commission to accept the joint stipulation. Thank you.
Is there any questions for Mr. Hatfield? Seeing none, we'll move into discussion and debate. Anyone wishing to discuss or debate this proposed stipulation any further? Seeing none, I'll entertain a motion for adoption of the stipulation.
So moved. Second.
All those in favor?
Aye.
All those opposed? The ayes have it. The stipulation is adopted. Thank you, Ms. Hadley. Thank you, Mr. Hatfield.
Thank you very much.
Moving to item 5 on our agenda. This matter is a consideration of the advocate's motion to dismiss complaint number 23-231, N. Ray Jonathan L. Owens. If the commission grants the advocate's motion, the matter would be dismissed. Alternatively, if the commission were to deny the motion, the case would proceed to the Division of Administrative Hearings for an evidentiary hearing, or the parties could reach a settlement agreement. Will the parties or their counsel please identify themselves for the record?
Melody Hadley, Commission Advocate.
Dennis Green on behalf of Jonathan Owens.
Thank you. Are there any members who need to make a disclosure? Seeing none, Ms. Hadley, you are recognized for your motion.
On March 8th, 2024, based on information that was available at the time, the commission found probable cause that respondent violated section 112.3138 by disclosing or using information not available to members of the general public and gained by reason of his official position for his personal benefit or for the benefit of another person. In preparing for trial at the Division of Administrative Hearings, where clear and convincing evidence is required to prove a violation, witnesses were re-examined and relevant case law was published. For one, attorneys for both sides of the lawsuit against Escambia County opined that the disclosure of privileged communications was not a significant factor in the $5 million settlement of the case. And the first DCA issued an opinion in 2025, Underhill v. Commission on Ethics. In that case, Commissioner Underhill also disclosed privileged attorney-client communications pertaining to pending Escambia County litigation and was found to have violated Section 112.3138 by the lower court. In its opinion, the Underhill Court opined that for purposes of the relevant section, the receipt of privileged attorney-client communication does not by itself amount to a benefit. Wherefore, in the absence of clear and convincing evidence to establish that the respondent violated Section 112.3138, I request that the case be dismissed.
Thank you, Ms. Hadley. Any questions for Ms. Hadley at this time? Seeing none, Mr. Green, you're recognized.
Sure. We just ask that the commission accept the recommendation from Ms. Hadley.
Any questions for Mr. Green? Seeing none, we'll entertain questions and discussions and debate regarding this matter. Any commissioner wishing to discuss this matter further before voting? Seeing none, entertain a motion for adoption of the advocate's motion.
So moved.
Second.
All those in favor?
Aye.
The motion is granted. Thank you, Ms. Hadley. Thank you, Mr. Green. The next matter on the agenda for consideration of dismissal for lack of jurisdiction in complaint number 25-064, N. Ray Rod Lincoln. I'm going to pass the gavel on to our vice chair as I have a voting conflict on this agenda item and therefore I will be abstaining. I have a professional relationship with Mr. Lincoln pertaining to a matter unrelated to the vote before the commission, and I will be filing a voting conflict memorandum.
All right, thank you. Are there any other members who need to make a disclosure? All right, then we'll go ahead and recognize Ms. Naomi to present the draft order.
Thank you, Mr. Vice Chair. So this matter concerns Rod Lincoln, who formerly served as a member of the Villages of Pasadena Hills Advisory and Planning Committee. So pursuant to Section 112.3145, subsection 9C, the commission initiated an investigation to determine whether Mr. Lincoln's failure to timely file his 2021 Form 1 was willful, as Mr. Lincoln accrued the maximum automatic fine for that form year, which is $1,500. Ultimately, the commission did find probable cause that Mr. Lincoln did willfully fail to timely file his Form 1. Now, when this matter went to DOA, Mr. Lincoln then notified the commission that he resigned from his public position. And because the holding of public office or employment is necessary to invoke and maintain the commission's investigatory jurisdiction under Section 112.3145, subsection 9C, the public interest would no longer be served by further proceedings, as the only penalty for a finding that someone willfully failed to file his or her financial disclosure is that the commission enter an order recommending that the person be removed from his or her public position. As such, where Mr. Lincoln is no longer in his public position, we recommend utilizing Section 112.324, subsection 12, to dismiss the case. This statute provides that the commission may, at its discretion, dismiss any complaint or referral at any stage of disposition should it determine that the public interest would not be served by proceeding further. So with that, I now submit the draft order for your consideration, and I'm happy to answer any questions.
Thank you. Do we have any questions for Ms. Naomi? All right, Mr. Herron.
Mark Herron on behalf of Rod Lincoln. We concur in the motion to dismiss. It is consistent with actions of this commission in other cases.
Thank you. All right, do we have a motion to approve or reject the dismissal? A motion to approve?
So moved.
Second.
All right, do we have any discussion? No discussion? All those in favor? Aye. Any opposed? All right, the motion passes, and I will now hand the gavel back to the chair.
Thank you, Mr. Vice Chair. Next on our agenda is the consideration of legal sufficiency for complaint number 26-082, N. Ray Jackie Espinoza, and complaint number 26-163, In re Jeanette Martinez. The next two items are staff recommendations of legal insufficiency of 26-082, In re Jackie Espinoza, and 26-163, In re Jeanette Martinez. These matters are being considered during public session because the respondent in each complaint waived confidentiality. Commission rules do not permit participation by the respondent or complainant at this stage of the complaint process. Members, you have written staff recommendations for each of these matters in your materials that you have reviewed in advance of this hearing. Does any member wish to have staff present the recommendation in either of these matters or have a disclosure to put on the record? Seeing none, we're going to take these up together. Is there a motion to adopt the public report in order dismissing the complaint?
So moved.
Is there a second?
Second.
All those in favor? All those opposed? The ayes have it. The motion to adopt the public report in order dismissing the complaint have been adopted. Next on our agenda is a consideration of DOA recommended orders of cost and fees petition. This is for complaint numbers 23-262, 23-264, 23-270, and 23-278, which are being consolidated together in In re Michelle Myers. We have before us the recommended order after remand from the Division of Administrative Hearings. This is an attorney's fees proceeding wherein the administrative law judge is recommending that we award fees against the complainant. Two complainants have filed written exceptions. The petitioner has filed responses to these exceptions. Under the Administrative Procedure Act, our review of the recommended order is like the review of it by an appeals court. We cannot take any new evidence, and we are limited in our consideration of the order. The Commission may adopt the recommended order as its final order. The Commission may not reject or modify findings of fact unless it first determines from a review of the entire record, which has been provided to you in your materials, all the transcripts and exhibits, and states with particularity in the order that the findings of fact were not based upon competent substantial evidence or that the proceedings on which the findings were based did not comply with the essential requirements of law. The Commission may reject or modify the conclusions of law over which it has substantive jurisdiction and the interpretation of rules over which it has substantive jurisdiction. But it must state with particularity its reasons for rejecting or modifying such conclusions of law or rule interpretation. As well, it must make a finding that its substituted conclusion of law or rules of interpretation is as reasonable or more reasonable than which was rejected or modified. Rejection or modification of conclusions of law may not form the basis for the rejection or modifications of findings of fact. Do any members have to make a disclosure with regards to this matter? Seeing none, will the parties or their counsel please identify themselves for the record? If you can, each of you come to the dais.
Good morning, Commissioners. So my name is Kim Fernandez here on behalf of complainant Kevin Toe.
Mr. Heron?
Mark Heron on behalf of Christopher Doc Bailey, and I see another council approaching.
Yes.
Good morning. I'm Susan Erdely, appearing on behalf of Michelle Myers. We're the petitioner.
Thank you, Ms. Erdely.
Thank you, Mr. Chair. So this matter concerns a petition for costs and fees filed by Ms. Michelle Myers against Mr. Kev Toe, Mr. Christopher Doc Bailey, Ms. Linda Young, and Ms. Diane Sykes. So in 2023, Mr. Toe, Mr. Bailey, Ms. Young, and Ms. Sykes filed nearly identical complaints against Ms. Myers, and she hired an attorney, Ms. Susan Erdely, to represent her in those matters. Ultimately, those 4 complaints were consolidated and investigated, and the commission found no probable cause in the matter. Shortly thereafter, Ms. Myers filed a petition for costs and fees pursuant to Section 112.317, subsection 7. To give some background on how that process works, if the commission determines that the facts and grounds alleged in a petition are sufficient to state a claim for costs and reasonable attorney's fees, the commission chair shall direct that the petition be heard before the Division of Administrative Hearings, which we refer to as DOA. So in this case, the commission considered Ms. Myers' petition, found it was sufficient to state a claim for costs and attorney's fees, and referred the matter to DOA. Now, regarding what happens to an attorney's fees petition once it goes to DOA, it is assigned to an administrative law judge, which I'll refer to as an ALJ. So after the ALJ conducts a hearing on the matter, the ALJ is required to complete and submit to the commission and all parties a recommended order consisting of findings of fact, conclusions of law, and a recommended penalty. Once the recommended order is entered, the parties have 15 days in which to submit written exceptions to the order. Unless all of the parties agree to waive the deadline within 90 days of the ALJ's issuance of the recommended order, the commission is required to enter a final order either adopting or modifying the recommended order, including an explicit ruling on each of the parties' exceptions. So turning back to the facts of this matter, the ALJ assigned to the petition conducted a hearing and issued his initial order in the case on January 7th, 2026. The recommended order recommended that the commission enter a final order granting Ms. Myers' petition for costs and fees in the total amount of over $25,000 against all 4 complainants jointly and severally. Now, you might remember that at our March meeting, you voted to remand the case back to DOA due to the issue of joint and several liability, as well as the ALJ's failure to make the required findings under Patients' Compensation Fund versus Roe. Now, I'm going to discuss here the standards you have to keep in mind when considering the respondent's exceptions. So, under Section 120.571L Florida statutes, an agency may not reject or modify findings of fact made by the ALJ unless a review of the entire record demonstrates that the findings were not based on competent substantial evidence, or that the proceedings on which the findings were based did not comply with the essential requirements of law. The agency may not reweigh the evidence, resolve conflicts therein, or judge the credibility of witnesses, because those are matters within the sole province of the ALJ. Consequently, if the record of the DOA proceedings discloses any competent substantial evidence to support a finding of fact made by the ALJ, the commission is bound by that finding. Under Section 120.571L, an agency may reject or modify the conclusions of law over which it has substantive jurisdiction and interpretation of administrative rules over which it has substantive jurisdiction. Now, when rejecting or modifying such conclusions of law or interpretations of administrative rules, the agency must state with particularity its reasons for rejecting or modifying such conclusions of law or interpretations of administrative rules, and must make a finding that its substituted conclusion of law or interpretation of administrative rule is as or more reasonable than that which was rejected or modified. Now, after the remand on April 10th, the ALJ issued a recommended order after remand, which I'll refer to as the ROR. And this recommended order after remand assessed an individualized penalty against each respondent to the petition and made the required findings by Roe. Before you now is a draft final order incorporating the RO and the findings in the ROR, which supersede the deficiencies with the original order. Mr. Herron and Ms. Fernandez filed exceptions, and Ms. Erdelai filed a response to those exceptions. Now, for the reasons outlined in the draft final order in front of you, each of Mr. Herron's and Ms. Fernandez's exceptions were denied. Some exceptions concerned the issues that were addressed by the order after remand and therefore were rendered moot by that order. The rest of the exceptions sought to change the order in a way that would make Mr. Bailey and Mr. Toe not liable for fees and costs. However, there was competent substantial evidence in the record to support the ALJ's findings of fact, and the ALJ's conclusions of law were reasonable. If you have any questions about any particular rulings on any exceptions, I'll be happy to answer them. And with that, I now submit the draft final order for your consideration. And again, I'm happy to answer any questions.
For hearing from the council for the respondents, is there any member that has questions for Ms. Naomi? Seeing none, we'll first recognize Ms. Fernandez, attorney for respondent Toe, is recognized to speak and take questions from members. Ms. Fernandez, you're recognized.
Thank you very much. I appreciate it. I respectfully ask that you review two things, two small paragraphs in the order that you're being asked to vote upon. And that is the footnote 4 to paragraph 40, as well as paragraph 56. And the reason that I'm asking this is because those paragraphs stray far beyond this commission's task on the petition for fees. Recall that we're looking at a complaint. We're looking for, in order to award attorney's fees, we're looking for a complaint filed against a public officer with malicious intent to injure the reputation of that officer through false allegations or reckless disregard for the truth. Paragraph 56 and footnote 4 blatantly stray beyond the confines of that statutory duty. Footnote 4 says, when questioned by the investigator, Mr. King, who is not a party to this matter, declined to be recorded, citing fear of respondent's alteration and manipulation of his words. And during his testimony in the hearing, Mr. King was reluctant to turn his video on to testify, citing fears and malicious recordings and manipulation of the video. His fear appeared genuine, and he cited prior claims of maliciousness by respondent Kevin Toe, who initially introduced himself to Mr. King as Charlie Bell in both person and online. Not one word about that statement has anything to do with the complaints, the responses, the statute that asks this commission to make a decision on attorney's fees. And it's for that reason that I'm just asking you to review it and consider whether that should be something that this commission actually approves and includes in an order that they're signing off on. Paragraph 56 says, in addition to evidence demonstrating that the complaints contain material false allegations. Let me stop right there. It starts, in addition to evidence demonstrating that the complaints contain material false allegations. That's where the statutory duty of this commission ends. The rest that the ALJ said was, there was also evidence submitted showing the respondents engaged in efforts to attack or discredit petitioner prior to filing the complaints. These efforts included an unsuccessful recall petition. So prior to the complaints that brought this matter to this commission for a decision, a recall petition was filed. Again, nothing to do with what we're here for today. And harsh internet postings were made by some of the respondents. I won't even get into First Amendment, but this entire paragraph after the finding, which I'm not challenging, in addition to evidence demonstrating that the complaints contained materially false allegations, fine. Everything after that statement, though, has nothing to do with this commission. And I urge this commission not to include that in and sign off on something that says that, which is far beyond their responsibilities. I'm not standing here to pound the podium and urge you to deny fees. That ship sailed a long time ago, as based on the history that you are given by Ms. Naomi. Just consider for a moment that this isn't really about the fees. Ms. Myers hasn't paid any fees. Insurance paid the fees. I offered to pay the fees a long time ago. It's not about this. It's about this order. And that's why I'm asking you to drill down and consider these two paragraphs. So I want you, commissioners, to have a clean, tight order by the books, sticking to the assignment and following the law. Please consider these two statements as not a part of your job. Thank you.
Thank you. Is there any questions for Ms. Fernandez? Thank you, Ms. Fernandez.
Thanks.
Mr. Herron, you're recognized for Respondent Bailey to speak and take questions from the members.
Thank you. For the new members, just to let you know, the commission doesn't do this every day. This is something that happens infrequently, whether it be a petition to grant fees or a recommendation by staff to deny fees. It's a very high burden established under the law for this commission to award fees. And it's quite a endeavor by persons who are claiming fees. With respect to the exceptions that Mr. Bailey filed, we are going to rely on our paper filings. But I'm going to bring up 3 points that I think that are important within those filings that we have made. For the most part, as been told to you by staff, there is competent substantial evidence in the record with respect to a number of these findings. As Ms. Fernandez just told you, a lot of those findings are totally irrelevant to the issues at hand. And I'll give you, this is my first point. I'll give you an example of some of those findings that are in the record, no way to challenge them, but they are irrelevant to whether Mr. Bailey acted in violation of the statute. For example, the fact that he didn't want to be interviewed during the investigation has no relevance to whether he filed a complaint with malicious intent. That he had no documents, totally irrelevant. Again, the evidence in the record show that he was aware of this situation regarding the grants by his service on the city commission of Crescent City. The fact that he's removed by the governor, no relevance to the allegations in the complaint. He was removed by the governor for a prior conviction in Missouri, which he believed had been resolved by Missouri law. That's been litigated. The courts have said Missouri law didn't control in this situation, Florida law did. He was removed, but it has nothing to do with the allegations that he filed a complaint with malicious intent. The fact that he signed recall petitions has nothing to do with the issue, as Ms. Fernandez just told you. The evidence also showed that he made no internet postings, although in the findings of fact, it's basically he's painted with a broad brush that he did. So again, there are a number of irrelevant facts that are in the order. The second issue I want to bring to your attention is the testimony of Mr. Rudd. And it's sprinkled all over the order. Mr. Rudd's testimony, it's sprinkled all over the draft order that you've been presented by staff. If you look at the actual testimony, Mr. Bailey recalled specifically that he discussed this matter with Mr. Rudd, has a clear recollection of it. Rudd, on the other hand, says, I had no recollection. Well, we all know that, that's one of these statements that people make that when they really don't want to recall something. I have no recollection. How do you prove you have no recollection of it? But again, the ALJ kind of focuses on that and makes a number of findings that are somewhat key to a finding that Mr. Bailey filed these things with malicious intent. Now, I know you were told that we shouldn't take anything outside the record. But it is important to note that Mr. Rudd, in his subsequent employment, has had serious issues and he's been moved from his job.
Mr. Herron.
I'm done with it. I'm done with that statement. I get it. But again, that's important in terms of the credibility
No,
determination.
Mr. Herron, that's outside the record. You have to stay within the record.
I'm with you. I got it. Mr. Bailey wanted me to bring that to your attention. And finally, the third issue I want to bring to your attention is this. The administrative law judge, the staff, considers this issue of, do you need to have expert testimony to approve and to determine whether the rate is reasonable and the hours are reasonable? It's not in this case. There's no expert testimony to that effect. The staff, everybody wants to say, hey, it's not necessarily, because the Sixth District Court of Appeal just recently said, we don't think it's necessary. And then they cited 100 cases where, maybe not 100, but scores of cases where it is necessary. So this basis of not having attorney's fees proven up in the course of the hearing is an issue. The fact that the insurance company, which again, you heard that the petitioner has not paid any attorney's fees because the insurance company paid them. The fact that the insurance company pays them doesn't mean they're reasonable. It's basically the rate the insurance company is going to pay. That doesn't mean it's reasonable. So again, we rely on our filings with respect to the initial recommended order and the supplemental order, and would ask you to find that Mr. Bailey is not fully liable for 1/4 of the fees. In fact, he's probably not liable for any of the fees. Thank you.
Mr. Aaron, you mentioned there was no Facebook post. In the proposed order before us, there's multiple citations to the transcript. In addition, my review of the transcript, I also noticed that on page 110, 1214, Mr. Bailey, before your representation, when he was representing himself before the hearing, said on 10 to 14, excuse me, 12 to 14, on transcript volume 1, he specifically asked, have you ever seen any Facebook postings that I, in particular, Mr. Bailey, have put out bashing the mayor, as you said? Answer: I've seen Facebook posts from you, as people have showed me, and I don't recollect specifically that they were what they were in reference to. But then later, on 157, there was another testimony about specifically Mr. Bailey putting out Facebook posts.
Again, who's the witness that's testifying? It's not Mr. Bailey. Mr. Bailey said he put out no Facebook postings with respect to this matter.
Right, but in terms of evidence in the record.
I don't recall. That's in that statement you read the first time. I don't recall.
Well, the other person wasn't Mr. Rudd, sir.
Okay, again, I hear you. I understand that. Mr. Bailey said he didn't do it clearly.
Okay. We will move on. I believe Ms. Sykes and Ms. Young in their counsel are not present. So we'll move to Ms. Erdely. Attorney for Ms. Myers is recognized to speak and take questions from the members.
Thank you. I want to give a little bit of background as to why this petition was filed. There was a prior complaint filed with the Commission on Ethics, well before any of you were on this board, against my client. It contained false claims against her. It was filed by Kevin Toe, who is represented by Ms. Fernandez. After going through that process and being found to have no validity, Mr. Toe, within months, filed yet another complaint against her. And then there were 3 other people who filed the exact same set of facts against her. These facts were false and they were malicious. And what happened is the commission had an investigator investigate all of those facts. This is the second round for my client. And because of the investigator's findings, after speaking with 3 of the 4 complainants, by the way, Mr. Bailey did not respond to phone calls from your investigator. He didn't refuse to talk. He just didn't return the phone calls after filing a sworn complaint. So the investigator found there was no evidence to support the complaint. And because this was the second complaint against my client by one of the complainants, and because it looked conspiratorial in this complaint, they all signed the exact same set of facts, and they weren't true. We felt that we needed to file this petition for hopefully to deter filing false and malicious claims. What do we have to prove? And I think it's important to point out that the evidence was seen by an administrative law judge over the course of 2 days. He eyeballed the witnesses. He saw their demeanor. He heard the tremble in the voice of city employees who said that they were afraid and that there had been false and malicious things stated about them by this little group. And so the evidence that the ALJ found supported our claim that the claims against our client were false and malicious. That's what we had to prove. I want to speak to what Ms. Fernandez raised. First of all, insurance is paying for Ms. Fernandez too. Second of all, she wants you to take things out of the recommended order. Your staff has done a lot of work in this case. We're hoping that this ends it, that we don't keep coming back to you with yet more false and malicious claims. That's the purpose of doing this, is to deter. That's the reason the legislature afforded us this tool in the statutory tool chest. So a good woman's reputation has been maligned here. What she's done with this petition has gone hopefully a long way for recouping her reputation. And we would encourage you to follow the recommended order by the administrative law judge and by your staff. I want to point out that the things that Ms. Fernandez wants you to pull out of the recommended order should not be pulled out. There was testimony that Mr. Toe introduced himself to a witness as Kevin Bell, Charlie Bell. That is important to point out, that he misled people. That was my job here, was to point out false and malicious claims. He had a pattern of falsehood, and that was the goal in pointing that out in the case. So I do think that's important, and I think it's relevant. I had the duty to prove maliciousness. That's what the statute says. That's what the judge found. So we would discourage you from deviating from what your staff recommends. Mr. Heron pointed out that these are infrequent petitions. They're infrequent for a reason. But when one needs to assert them, they need to assert them. And the reason is to discourage yet more false and malicious claims. We think the findings are relevant in this case. Mr. Heron told you that his client didn't want to be interviewed. Not true. His client testified that he never heard. He didn't know why the investigator never reached out to him. The investigator testified he tried multiple times to reach out to Mr. Bailey. Mr. Bailey was not represented by counsel at the hearing. These claims about attorney's fees amounts were not raised at the underlying hearing. Therefore, they were waived. The fact that Mr. Bailey was removed by the governor is important, because he testified that he faulted the mayor, who, by the way, wasn't the reason the governor removed Mr. Bailey as a commissioner, but that shows falsehood. And so we felt that was important, and the administrative law judge felt it was important. If it wasn't, he wouldn't have put it in his order. It showed a pattern of untruthfulness, and Mr. Bailey felt, he admitted that he faulted the mayor because he believed she did something that led to his being removed as a commissioner. Thus, his complaint was filed with maliciousness. That is relevant. That's probably why the ALJ put it in the order. You've been told that Mr. Bailey said some things to Mr. Rudd about a CRA grant. Mr. Bailey wasn't in office when the CRA grant at issue here was being considered. He wasn't on the board at that time. My client was accused of finagling to get a CRA money to a citizen in return for political favor. None of that was true. It was totally fiction, no evidence of that. So we would encourage you to follow the direction of your staff. They've worked really hard. They've been really professional. We've handed them a challenging situation of 4 individuals who got together and made up a claim against my client. And if what's to deter that in the future, what's and what we are seeing, and this is why the mayor felt it was important to file this petition. We're just not seeing people willing to face off to that kind of maliciousness and falsehood in running for office. You're on a board. You know what it takes. People can make things up about you. They can put it on Facebook. They can put it out there. And you can either stand your ground and say it's not true, or you can take your first time that you prevail in front of the Commission on Ethics and go home, which is what she did. But when it keeps coming at you another time, it's not going to stop. We want to encourage good people to sit for office. And that's what this mayor has done. We don't want to discourage it. Therefore, I would encourage you to follow the direction of your staff and issue the recommended order that she's handed you.
Thank you, Ms. Early. Do any of the members have any questions for Ms. Early at this time? Seeing none, thank you.
Thank you.
Do any of the members have any questions for Ms. Naomi before we move into deliberations and discussion?
Mr. Chair?
Yes.
I do. For Ms. Naomi, in the intro, Ms. Naomi, you covered some, like what are the boundaries of what we could do? And based on that, can you just highlight that again one more time for me, please?
So through the chair, there's 2 standards that I talked about. The first one pertains to the exceptions to any findings of fact. So basically the standard there is either that the underlying proceedings did not comply with law, or that there's no competent substantial evidence in the record. And in terms of what competent substantial evidence means, it's a really low bar. Essentially, if you have 2 witnesses that testify to 2 opposite things and the judge believes one or the other, that's enough because it's in the record. So that's competent substantial evidence. Now, in terms of conclusions of law, we can grant exceptions if you guys feel that the ALJ's conclusions are not reasonable. So essentially, if there is another conclusion that is as or more reasonable than the ALJ's conclusion, then you can grant those exceptions.
Mr. Rogers, do you have any follow-ups?
No further questions. Thank you.
Thank you. Any other questions for Ms. Naomi before we move to deliberation and discussions? Thank you, Ms. Naomi. We'll move to deliberation and discussions. Is there any member that would like to be recognized first for deliberation and discussions on the issues for us? Okay. I just want to put something so that we have it for the record. With respect to the attorney fee expert issue, as was referenced in the staff's recommendation, the 6 CCA and Ruffenach v. Deutsche Bank, National Bank, Trust Company, 431 Southern 3rd, 1055, address the issue of whether an expert witness is necessary for fees. And in that decision, Judge Mize recognized that the trend in the 4th DCA and the 5th DCA, and now officially in the 6th CCA, is that a fee expert is not necessary based on the circumstances such as this one. And that although the 6th DCA is the first to rule such, there was a trend in the 4th and the 5th, and as well relying on examples from the federal courts stating that there was no evidentiary hearing. This is at Penn sites 1065 to 1067. I do have some reservation about some of the language that was in the DOA order. However, it does provide context, and I don't see it as being used for propensity evidence, but rather to provide context to the situation. And although it may be dictum, it does not impact the ruling and the findings of fact that the judge reached in making its determination on fees. So what I would recommend is affirming the order and entering the order proposed by staff. Any further comments?
Mr. Chair?
Yes.
So first, thank you for pointing out the previous background on the fees. That's helpful for me. And I agree. I think I don't see it as, I think our place has a body to change that language. I think you made the case, so I concur.
I understand a motion to adopt the proposed order.
So moved.
I'll second.
All those in favor?
Aye.
All those opposed? The ayes have it. The order is approved. Thank you, attorneys, for your presentations, Mr. Heron, Mr. Fernandez. Certainly, we appreciate your thorough preparation for today's hearing. And of course, Ms. Naomi. We'll now move into the consideration of advisory opinions. First will be file 2836, post office holding restrictions. Any public officer, candidate for public office, or public employee in Florida who has questions about the applicability of the disclosure laws or standards of conduct to himself or herself, or anyone who has the power to hire or terminate another public employee, may seek an advisory opinion from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Are there any members of the commission who need to make a disclosure regarding this matter?
Okay. Mr. Chair?
Yes.
I just want to state for the record that my wife is a deputy secretary at DBPR.
And we will now recognize Mr. Schaefer to present the draft opinion.
Thank you, Chair. This opinion request is being brought by a former attorney for DBPR. She left the agency and is now operating a private law practice. And her inquiry concerns to what extent a particular post-employment statute will prohibit her from representing clients in matters involving DBPR. Now, the statute in question is Section 112.313, subsection 9A4. That law applies to former executive and legislative branch employees serving in specific types of positions during their public employment, and it places a 2-year prohibition on them returning to represent clients for compensation before the agencies where they were employed. So we're dealing here with a 2-year post-employment representation ban. And most questions involving this law hinge upon determining the extent of a former employee's agency. And as I'm going to discuss, that's what this opinion focuses on as well. Just to give you the background on this, the statutory definition for the term agency, as that word is used in the statute, it's defined in the Code of Ethics. It just lists different types of governmental units that can be one's agency. That list includes not just state departments, but state divisions and bureaus as well. Each of those types of governmental units, both large and small, meet the definition of one's agency. Because the statutory definition of agency covers smaller units of government, the Ethics Commission has found in the past then that a former employee's agency might not necessarily be the entire state department where they were employed, but rather the lowest departmental unit or units where they had influence. So that means that a state employee's agency for the purpose of this 2-year post-employment statute may just, in individual circumstances, be the division or even the small bureau where they were working, as opposed to the entire state department as a whole. So that's the legal background. With that in mind, let's look at this former attorney's employment at DBPR. She indicates she was hired back in 2019 to serve as an attorney within the Office of General Counsel. In particular, she was hired to work in the General Counsel's Construction Industry Licensing Board legal unit. Now, that legal unit is exclusively involved at DBPR in presenting disciplinary and licensing matters to a particular DBPR board called the Construction Industry Licensing Board. I'm going to be referring to it as the CILB. That was her sole responsibility the entire time she was at DBPR, to present matters to the CILB. She indicates she had no contact with attorneys or staff outside her legal unit and the CILB. And even within her legal unit, her contact with staff recently has been more scarce. She's told us that in June of 2024, a little over 2 years ago, she began working in a part-time remote position. And from that point on, until the date she resigned, which was in April of this year, her only contact was with her direct supervisor and an administrative assistant within her legal unit. So we have a fairly unique situation here. We have a state employee who had very limited influence while they're in public employment. Really, she only had contact with the members of her legal unit and with the board members and the staff of the CILB. So the question now is what the extent of her agency should be for the purpose of this 2-year post-employment statute. You know, how wide should we be casting the net when we tell her which parts of DBPR should be prohibited from representing clients in front of? And this question is important for the requester because she hopes in private practice to represent clients in matters involving DBPR. So if her agency is the entirety of DBPR, or even just the entirety of the Office of General Counsel, that's going to effectively preclude her for the next 2 years from representing clients in DBPR matters. Now, I want to circle back to a point that I made earlier, which is that the statutory definition of the term agency hinges on the extent of a person's influence. If a former public employee had limited influence while in public employment, their agency is just considered to be those units where their influence extended, not the entirety of the department where they were employed. And as you can read in the draft, the Commission has applied this reasoning in past opinions in the context of DBPR, finding a former DBPR employee's agency for the purpose of this 2-year prohibition are just the legal unit, are just the units within DBPR where they had influence. So looking here at this situation, the attorney presented matters to the CILB. So her agency for the purpose of the 2-year prohibition obviously would be the CILB board members and its staff. For 2 years, she won't be able to represent clients for compensation on matters going before the CILB because she had influence before that board. But the more complex question here concerns DBPR's Office of General Counsel. As I said, she was hired to work in an attorney position within the General Counsel's Construction Industry Licensing Board legal unit. So the question here is, does that mean that her agency should encompass then, in addition to the CILB, the entirety of the General Counsel's office? Now, from what I could tell, the Commission has never before issued an advisory opinion breaking an Office of General Counsel down into smaller components. And that is why we're suiting it up as a formal opinion for you today. It's just a question that we've never considered before. Now, this makes sense in most circumstances. Organizationally, an Office of General Counsel of the State Department is usually considered by the department to be one solitary unit. On the last page of your meeting materials, I included the DBPR organizational flow chart. And if you look at that on the flow chart, it just lists the Office of General Counsel as being one solitary unit. It doesn't break it down any further than that. Also in the past, when we have had post-employment questions coming from attorneys that are either employed by an Office of General Counsel or interface often with an Office of General Counsel, those have been matters where they have worked throughout the office, working with many, many different attorneys and staff, many different sections within an Office of General Counsel. Because of their wide range of work, the Commission has found that their agency is the entire Office of General Counsel. So that's what we found in the past, and strictly speaking, I think an argument could be made that this attorney's agency is not just the CILB, but the entire Office of General Counsel at DBPR. But it seems to let the matter lie there and say that she's prohibited from representing clients before any nook and cranny of the Office of General Counsel really doesn't reflect the reality of her work when she was at DBPR. You know, apparently internally, the Office of General Counsel does have units, even if they're not reflected on the flow chart. And she was hired to work only within one of them, the Construction Industry Licensing Board legal unit. She had no contact with staff or attorneys outside her unit. She's been very clear that her responsibilities were limited just to her legal unit and presenting matters to the CILB. She had no duties elsewhere. And again, for the past 2 years, she's only had contact with 2 DBPR employees, her direct supervisor and an administrative assistant. So for those reasons, what the draft is recommending you find is that technically speaking, her agency for the purpose of this 2-year prohibition would be both the CILB and the entire Office of General Counsel, but that she won't violate the statute as long as she confines her work to parts of the Office of General Counsel other than her legal unit and other than the CILB. Now, we're getting there by using a statute that we've used in the past, Section 112.316. 112.316 is a law that the Commission can use when individual circumstances warrant it to negate a technical conflict of any of the prohibitions in the Code of Ethics. It can be used to allow a employee or former public employee from filing a particular employment as long as it won't breach the public's trust. Now, here the whole purpose of Section 112.313 subsection 9A4, this 2-year prohibition, is to prevent public employees from exploiting the knowledge they gain at their state agency for private gain after they leave public employment. That purpose seems honored here, even if you parse here DBPR's Office of General Counsel down into smaller units under these unique facts. This employee's influence was limited to the CILB and the Construction Industry Licensing Board legal unit. She had no responsibilities or contact elsewhere. So for that reason, the draft recommends that while you might find that her agency is the CILB and the entire Office of General Counsel, we can apply 112.316 to say that she won't have a conflict as long as she has nothing to do with matters involving her old legal unit or the CILB. That seems to serve the purpose of the statute, and it also reflects her unique circumstances. Now, before I close, I want to make just 3 quick points. First, this draft is written only to address this particular attorney and her facts. It doesn't mean that every Office of General Counsel attorney will have the same outcome. The analysis hinges on her very limited influence within the General Counsel's office. Another attorney who might have more wide-ranging influence, their agency might very well be the entire Office of General Counsel. And this draft opinion doesn't preclude you from finding that in the future. It's just tailored to her unique circumstances. Second, the draft also discusses if the post-employment law even applies to this requester, because she was OPS at the time she left DBPR. The law indicates it only extends to OPS employees if they have the powers that are comparable to someone who is certainly covered by the statute. Here, the attorney has indicated even though she was OPS at the time she left DBPR, her duties were the same as any other SCS attorney within her legal unit. I think just her caseload was a little bit lighter. Because SCS employees are clearly subject to this 2-year post-employment statute, and because even though she was OPS, her powers were comparable to an SCS employee, we feel the statute then can be extended to her even though she was OPS. And third and finally, this pertains to footnote 6 of the draft. Not all of the work she hopes to do in private practice is going to trigger this 2-year prohibition. She's indicated that some of the work she hopes to do might not even require her to contact DBPR, and certainly that wouldn't trigger the statute. I just wanted to mention that as well. Thank you for listening to me. I offer this draft now for your consideration, and I'm happy to answer your questions. The requester, Ms. Cafruni, is here today as well, if you have questions for her.
Thank you, Mr. Schaefer. Is there any questions from the commission with regards to the proposed opinion? Seeing none, we'll give an opportunity. Ms. Cafruni, would you like to make any comments with respect to the opinion? If you can come to the dais, please.
I think he addressed everything on point. I couldn't have said it any better. I just want to thank you guys for taking the time to review it.
Thank you, Ms. Cafruni. We'll move into discussion and debate. Anyone wishing to discuss this opinion further?
Mr. Chair?
Yes.
Thanks, Mr. Chair. Mr. Schaefer, I concur with the finding. I think you broke it down really, really well. It's a nuanced space. I think that if the requester had not been OPS, I know you stated that the roles were similar, but it still does seem like a more limited function that she was in after that, based on the part-time status and some of that. So I just really appreciate the nuanced breakdown. And as you point out, this applies to this specific case, doesn't mean it's going to be carried out for others. So thank you.
Commissioner Rogers. I concur. I appreciate it being narrowly tailored to the specific facts of the CILB and the role in which this requester acted in that division, and not the whole DBPR, which is a very large agency. We'll entertain a motion for adoption of the draft opinion.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
All those opposed? You guys have it. The draft opinion is adopted as written. Thank you.
Thank you.
We'll move on to the second advisory opinion for consideration, file 2837, constitutional representation restrictions for state legislators. Again, any public officer, candidate for public office, or public employee in Florida who has questions about the applicability of the disclosure laws or standards of conduct to himself or herself, or anyone who has the power to hire or terminate another public employee, may seek an advisory opinion from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Are there any members of the commission who need to make a disclosure regarding this matter? Seeing none, the chair recognizes Ms. Naomi to present the draft opinion.
Thank you, Mr. Chair. So this opinion concerns a state representative who's also an attorney in his private capacity. So to provide some factual background, the representative's law firm is considering providing regulatory and administrative counsel to a client that's regulated by ACA, which is a state agency housed within the executive branch. Naturally, the firm's services would involve representing that client before ACA. As such, the representative has asked about the boundaries of what we call the in-office representation ban for state legislators and its applicability to this scenario. So the two relevant provisions of law that I will be discussing are Article 2, Section 8E of the Florida Constitution and Section 112.313, subsection 9A3A Florida statutes, and they are nearly identical. They both provide that no member of the legislature shall personally represent another person or entity for compensation before any state agency other than judicial tribunals. The definition of represent is quite broad. It includes attending agency proceedings on behalf of a client, writing letters or filing documents, and personal communications with officers or employees of an agency on behalf of a client. So clearly, the representative here would therefore be prohibited from engaging in any of these activities at ACA on behalf of the client. However, he's asked about how the ban applies if other attorneys in his firm represent the client before ACA. Now, in past opinions, the Commission has recognized that the firms of state legislators may engage in representation before state agencies, as long as the legislator does not personally engage in the representation. This interpretation is also consistent with the plain language of the ban. So while other attorneys in the representative's firm can engage in this representation, the representative will still have to complete a Form 2, which is a quarterly client disclosure that's required of reporting individuals when they or their partners in their firms represent clients for compensation before agencies at their level of government. So the next question addressed by this opinion concerns whether the in-office representation ban will prohibit the representative from representing the client for compensation before a judicial tribunal in litigation involving ACA, including participating in settlement negotiations. The draft concludes that this conduct would not be prohibited by the ban. So both Article 2, Section 8E and Section 112.313, subsection 9A3A include an exception for representation before judicial tribunals. Section 112.313(9A)(3A) also explicitly brings settlement negotiations within its judicial tribunal exception. Additionally, the Commission has previously opined that the ban allows state legislators to personally represent clients in court in lawsuits against state agencies. The Commission's reasoned that even though the proceedings would be against a state agency, the proceedings themselves are before a court and not the state agency. Now, regarding settlement negotiations, the commission noted that because the plain language of the ban allows representation before judicial tribunals, all activities which are naturally attendant to representing a client before a court must also be permitted. Now, the final question addressed by this opinion concerns whether DOA falls under the judicial tribunal exception to the in-office representation ban. You may remember back in December when we addressed this issue in the context of the Florida Board of Bar Examiners and applied the four-factor test from Myers versus Hawkins to determine whether it was a judicial tribunal. The 4 factors outlined in the Myers case are 1, that the agency presides over proceedings that are adversary, 2, that the agency is comprised of an impartial group of decision makers, 3, the agency has the power to issue final orders that it also has the power to enforce, and 4, there's an identifiable appellate standard of review that can be used to test the agency's decisional processes to ensure due process. Now, after analyzing an agency's responsibilities in the context of these 4 factors, the Myers Court also emphasized a distinction must be made between agencies that possess the requisite judicial characteristics for only some aspect of their activities and those possessing those characteristics for all or virtually all of their activities. So ultimately, in applying the Myers test, it does not appear that DOA satisfies the 4 factors. Specifically, the factor concerning enforceable final orders is not satisfied for all of virtually all of DOA's activities. While DOA ALJs do have the power to issue enforceable final orders in some contexts, such as rule challenges, a large portion of orders that are issued by ALJs are recommended orders, such as the one you all considered earlier regarding the fees petition. For instance, in DOA proceedings where the substantial interests of a party are determined by an agency and there's a disputed issue of material fact, it is the state agency for which DOA holds the hearing that actually issues and enforces the final order in the proceeding. As we discussed earlier this morning, under certain circumstances, the state agency may reject or modify the ALJ's conclusions of law, the ALJ's interpretation of rules, the ALJ's findings of fact, and the ALJ's recommended penalty. So as such, DOA does not pass the Myers test, and it's not a judicial tribunal for purposes of the ban. And I'll note this is also consistent with a previous commission opinion that found that executive departments and administrative hearing officers fell within the ban. So with that, I now submit this draft for your consideration, and I'm happy to answer any questions.
Are there any questions from any of the members? Thank you, Ms. Naomi. I believe the requester is not present. And so we'll move on to discussion and debate. Is there any commissioner that wishes to discuss this opinion any further beyond the written materials that were provided to you in advance of the hearing? Commissioner Rogers?
Yep, thanks, Mr. Chair. I think just 2 things that I noted is in the Constitution, it mentions employees, but that applies to the state agency and government, I think, as I understand it. And then I see the language as very clear here when it says personally represent. If we wanted to change that, that's not our, that'd have to change in this statute. So I plan to support it.
Okay. Any further comments from any of the members? I'll entertain a motion for adoption of the proposed opinion as written.
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
All those opposed? The ayes have it. The opinion is adopted as written. Thank you, Ms. Naomi, for that draft opinion. Moving on to the consideration of an order on request for an extension. Request for extensions of time to file an annual financial disclosure form may be granted by the chair for up to 45 days. The matter before us is a request for a 243-day extension for filing a 2025 Form 1 brought by Ms. Stephanie Holmes on behalf of Maurice D. Sutton. The stated basis for extension is that Mr. Sutton is currently on military leave and deployed outside of the United States. The draft order grants an extension to March 1st, 2027 for Mr. Sutton to timely file his disclosure form. Are there any members who have questions or who would like to have staff present the draft order? If not, we'll entertain a motion to adopt the draft order.
So moved.
Second.
All those in favor?
Aye.
Anyone opposed? The ayes have it. The order is adopted as written. Thank you, Mr. Sutton, for your service. Next, we will move on to the consideration of rulemaking. We have one rule hearings on our agenda today. The purpose of a public hearing is to allow the commission to hear public comment, evidence, and argument about the proposed rule or proposed changes to an existing rule. Following the public hearing, the commission will decide whether to make any changes in response to public comments or written materials received, or whether to accept the rule as noticed. The commission may withdraw a rule in whole or in part, or may make such changes as are supported by the record of the public hearing or any written materials we have received. The commission also may make technical changes which do not affect the substance of the rule. I will ask Mr. Schaefer, who prepared the draft item, to explain the rule changes and put us in proper posture, and then we'll proceed to the public hearing, deliberation if it is requested, and the vote. Mr. Schaefer, you're recognized.
Thank you, Chair. Commissioners, as the Chair said, there's one rulemaking matter before you today, which we believe is fairly straightforward. It concerns amending Rule 34-7.025, which is a portion of the Commission's rules concerning ethics training. Just to give you kind of the background here, about 10 years ago, the legislature passed Section 112.3142. That was a statute in the Code of Ethics that says that certain types of public officers and employees have to receive 4 hours of training each year, and a portion of that training has to be on ethics. 112.3142 specified the exact officers who had received the training, indicated that the commission should adopt rules setting out minimum course content for the training. Based on that statute, about 10 years ago, the commission adopted Rule 34-7.025. That's our ethics training rule. It reiterates who's obligated to receive the training and then lists different subject areas they should aspire to cover during the ethics portion of it. During this past legislative session, the legislature passed a law amending Section 112.3142. The amendment stated that our rules should be revised to include 3 additional subject areas, and it gave us until November 1st to engage in this rulemaking. 3 subjects are: first, efforts by foreign countries of concern to target and influence subnational governments; second, how to identify, recognize, and report suspected foreign influence campaigns; then third, the enhanced penalties that have recently been added to the bribery statutes pertain to gifts coming from foreign countries of concern or designated foreign terrorist organizations. What we're proposing with this rulemaking is very simply to add those 3 subjects to our training rule. That's the entire purpose of the rulemaking this morning. I've submitted our proposed language to JAPSI, which just incorporates those 3 subject areas almost verbatim. I've received no feedback from JAPSI, which I believe means that they're comfortable with what we're proposing. And for those of you who don't know, JAPSI is a legislative committee that reviews all the different rules being proposed by state agencies to make sure they track the language of the statute that authorizes the rulemaking and that we aren't going outside the borders of what we have authority to do. Again, I submitted this language to JAPSI probably about 2 or 3 weeks ago. I haven't received any feedback from them, which means they're comfortable with it, I would think. So I submit it now for your review, and I'm happy to answer your questions.
Are there any questions from Mr. Schaefer? Seeing none, is there any member of the public who wants to be heard on Rule 34-7.025 of the Florida Administrative Code? Seeing none, we will move to if there's any comment or debate any further with regards to the proposed rule.
Yeah, Mr. Chair?
Yes.
Sorry, lots of comments and questions today. First of all, I applaud the effort on this, and there certainly are very active efforts by countries of concern to influence local officials, so I think this is good. Just question for Mr. Schaefer, the countries of concern, is that, I didn't see that defined.
Right. Foreign countries of concern, the definition that they put in our statutes, which they also did in the same bill that authorized this addition to our rulemaking, it defined the term designated foreign terrorist organizations as having the same meaning as how that term is defined in Chapter 775. And it defined foreign countries of concern to have the same meaning as already set out in Chapter 286. And if you look at Chapter 286, it lists different countries that are going to qualify as foreign countries of concern.
Yeah, Mr. Chair, that answers my question. I think there's some in that area where we restrict governments from using technology from those countries of concern. So this seems to line up with that. So I'm good. Thank you.
Thank you, Commissioner Rogers.
Chair.
Yes.
Commissioner Stewart. As a former state employee, I have some questions about the speed. I honor the staff getting this out so quickly. Little concerned that there's no public comment on a rule. And so just curious about kind of how long it's been posted. I think that the governor signed this in May, but it went into law July 1. So we're moving fast, which is great because there's a November deadline. I just was curious about any additional feedback
Sure.
and what it's going to mean for training and preparedness moving forward.
Sure. When we engage in rulemaking, there's a very specific process that we have to go through to make sure the public has plenty of time to comment. We have to publish in the Florida Administrative Register, which is a public document published daily by the Department of State. We have to publish at least 2 notices. The first is a notice of rule development, which basically just says the general subject area in which we're going to be engaging in rulemaking. And then I think we have to wait at least 7 days, and then we have to publish a notice of proposed rulemaking, setting out the exact language that we're going to be including in the rule, opening up the forum for public comment on the rule, and indicating if we're going to have a rulemaking hearing. You don't have to have a rulemaking hearing on a rule, although I can't remember ever a time when we haven't, when we're even amending our rules. Now, the notice of proposed rulemaking that set all of that out was published, give you the exact date. On June 26th of 2026. So, about a month ago. There, according to law, is, I believe, a 21-day period. It's either 20 or 21 days, and the public can submit comments. They submit comments to the Department of State, and we can check that on the Department of State's website. I've checked every single day, including this morning, and we have not received any comments on the rule. And this hearing was published, so there's been at least a month's notice of this hearing as well. And again, the other stopgap is that we have to present every rulemaking we're going to engage in to JAPSI. JAPSI reviews the rules to make sure that we aren't coloring outside the lines of any rulemaking authority given to us by the legislature. And I made sure I try to give it to JAPSI about 3 weeks before the meeting to give them plenty of time to review it. When we don't receive comments from JAPSI, they only get in touch with us, it seems, if they have problems with what we're proposing. And I haven't heard anything from JAPSI either. I checked JAPSI's website with Amelia this morning about that as well, just to make sure that there was no last-minute comments that had slipped through.
Okay, thank you.
Any further questions from commissioners? Seeing none, I'll entertain a motion and vote to file the proposed rule as written with the Department of State for adoption.
So moved.
Is there a second?
Second.
All those in favor of adopting the proposed rule as written with the Department of State for adoption, say aye.
Aye.
All those opposed? The ayes have it. The proposed rule is adopted for submission to the Department of State. Thank you, Mr. Schaefer, for the presentation. With that legislative feel, we are moving on to the 2027 legislative recommendations. We're going to begin our discussion of possible recommendations for the 2027 legislative session. You've been presented a memo in your materials outlining information on the 2026 recommendations that did not pass, as well as other possible recommendations for us to consider. We are not limited to the discussion of items on the list. Any member may have additional items they wish to have staff add or research for discussion at our next meeting. Ideally, we can take up our final consideration and adoption of legislative recommendations at our next meeting in August. Before we begin, are there any members of the public who wish to speak on this matter? Okay. Seeing none, I'll recognize Executive Director Stillman to provide some additional detail regarding the items in the memo that's in your materials, or that was sent, I believe was in the supplemental materials.
Thank you, Mr. Chair. Good morning, members. It's good to see everyone. This is really the beginning of your discussion. Steve and I register as the Commission's official lobbyists. Our agency is most successful when we have members of the Commission who are willing to engage in that process with us. It's very meaningful to members of the legislature when members of the Commission reach out and are active. So as a part of what you will ultimately decide, and today is just really the beginning and laying the groundwork for all of this, but ultimately you'll want to decide which matters you want to recommend, and then talk a little bit about the strategy as to how you want to go about that, if you're going to designate a member to kind of spearhead and make decisions on behalf of the commission, and work alongside Steve and I as we work your recommendations that will be published in our annual report. Thankfully, this year, legislative session begins in March and not January, so we do have a little bit of time to refine things. I want to get started, first of all, with talking about the whistleblower recommendation that has been on the commission's list of recommendations for a number of years, but became even more of a priority with the recent requirements of personal knowledge and information, other than hearsay being a requirement for the commission to do an investigation. We had strong sponsors once again. It was our year of having whistleblower legislation. Senator Gates and Representative Maney sponsored whistleblower legislation on behalf of the commission, both in the House and the Senate. It died on second reading, so we made it a good ways. It did seem to get it got some traction. It seems reasonable to think that citizens and officials alike would be in favor of providing protection to public employees who file a complaint based on their personal knowledge and personal information. The current whistleblower statute as written does not appear to protect public employees who file ethics complaints with the commission. Having a whistleblower protection as an avenue for those with personal knowledge about a possible violation of the ethics laws to provide some measure of protection, the commission has thought has made good sense. A few weeks ago, we were contacted by Commissioner Gates's aide, Davidson Oberste, to sort of debrief the last session that we had as they work to review last session with an eye toward 2027. Senator Gates, to my knowledge, has not decided what bills he might be interested in picking up for next year, but his aide did ask if Steve and I thought that the commission would be recommending that as a legislative priority again this year. Without this commission's pronouncement that it will be a recommendation, we're not able to commit the oomph of the commission on that matter. So my hope would be that maybe today we talk about this one a little bit, and it is my hope that perhaps if you got behind it again for this year, that the third time would be the charm. Moving on to the recommendation from last year that we passed regarding financial disclosure. This dealt with one-time fine waivers for individuals who have a automatic financial disclosure fine for the late filing of their Form 1 or Form 6. In the executive branch lobbyist registration system, they have to file compensation reports, and there has long been a first-time, one-time automatic fine waiver. In that law, it has worked well. The commission recommended it last year that there be a one-time, first-time fine waiver for an individual who had not accrued the maximum fine of $1,500. This recommendation supports the commission's goal of compliance while also providing better efficiency regarding these fines and appeals. Also, last year, there was a recommendation regarding records exemptions for you as members of the commission and for your staff. As you know, you rule on matters that are very, very important to members of the public, important to the public officers and employees who are subject to the commission's jurisdiction. There was legislation passed to provide a public records exemption for things like home addresses and telephone numbers. It did not pass. Similar exceptions already exist for individuals working in human resources, those who work with child support enforcement, child welfare investigations, property appraisers. You know, the reality is that the work that we do here does make a personal impact on those come before us. We have added in recent years additional security measures at our office at the urging of our members. We have received threats at times, acts of intimidation. I have personally been told that if I didn't change my mind about the matter that a person on the phone was speaking to me about, that he would make me his target. So these unfortunately do happen in this day and age. I think we've seen more and more of that with elected officials as well. Also last year, we had the change regarding the Form 10 to clarify the filing location, changed the law to clarify with the advent of electronic filing, that the electronic filing of Form 1 and Form 6, if an individual has to file a Form 10, which is an annual form that outlines gifts received from governmental entities, honorarium event-related expenses, the instructions in that tell them to file it with their Form 1 or Form 6. The Form 10 is a paper form. It's not a part of the electronic filing, and we cannot update the instructions of the form until the law allows us to update them to indicate that it's simply filed with the Commission on Ethics, because we can't engage in rulemaking, and forms are rulemaking without the specificity in the statute. Prior to electronic filing, there were local filers who filed with their local supervisors of elections. And so the current language in the statute and on the form is confusing to those who file the Form 10. We had a bill, it almost made it. It was amended late in the process, and then it went back and forth between the chambers and ultimately died. We also had technical changes, first of all, relating to allowing the postmark date for financial disclosure appeals count as the date received, because they have 30 days to file an appeal. Not everybody files their disclosure appeal electronically. We had also noted that it would be helpful to seek a clarification in the law that individuals appointed to complete the remainder of the term of a Form 6 office are required to go ahead and complete the Form 6. This is how we currently advise those individuals, but it would be nice to have it specified in the law. Another matter that we had also deals with ethics training. The law is specific regarding those who are appointed to fill a vacant elected position on an independent special district, that they're required to have those 4 hours of ethics training. However, there is not a similar specification when it comes to other officials appointed to fill vacant elected municipal officer positions. You could recommend that the law be changed to specify and make it consistent. I've gone over a few things from last year. Are there any questions or comments related to those, or shall I keep rolling?
Any questions from any of the commissioners with regards to the prior legislative agenda that we approved for 2026 or the technical edits? Please proceed.
Okay. Other ideas that the commission has talked about in the past relate to personal knowledge and information other than hearsay. If you decide to discuss possible changes with regard to this, something we talked about last year, and I believe it's in the draft language in your memo as well, that the commission be able to rely on things such as investigative accounting or audit reports commissioned by a public agency at the state or local level, as well as information and law enforcement reports to satisfy the information other than hearsay for purposes of ordering investigations. Another idea brought forth by a former commissioner when they discussed this issue was to enhance the referrals process for complaints, to extend the ability of the commission to accept a referral from state inspectors general, state agency heads, governing bodies of political subdivisions where the named respondent is a current or former public officer or employees. The referrals that you receive are not required to meet the personal knowledge or information other than hearsay. I think currently we can accept them from the governor, the state attorney, FDLE, federal prosecutors. So expanding that could be helpful in getting meaningful complaints and being able to rely on information that is given to inspectors general and auditors and investigators. Currently, many times when we see that in complaints, it's hearsay, or there's hearsay within those reports. And so things that the public and those auditors would think we would be able to pick up, we are not able to do. Another item that we have noted relates to executive branch lobbyist audits. Each year, there are random audits of compensation reports for executive branch lobbyist registration lobbying firms. As you know, the commission administers the executive branch lobbyist registration law, and we handle the registration and compensation reporting. The legislature has their own registration law. The legislature enforces 11.045 related to those. But there are random audits each year. 3% of executive branch firms are selected randomly. Executive branch audits that are completed are then provided to the commission. And the law says that the commission shall investigate any lobbying firm, lobbyist, principal, agency, officer, or employee upon receipt of information from a random audit indicating that the entity or individual has intentionally failed to disclose a material fact or has knowingly submitted false information in any required executive branch lobbying report. The reality is, with the requirement for something to be intentional or with knowledge, it is difficult for an auditor to make such a finding in an audit. The commission may want to consider a recommendation related to that intent requirement so that you could take action on material errors that are discovered as a part of that process. Turning to some glitches or more technical items that staff has noticed related to the gifts from designated foreign terrorist groups. The Ethics Statute 112.313 sub 2 was amended by House Bill 905 to prohibit soliciting or accepting things of value from a person or entity representing or acting on behalf of a designated foreign terrorist organization or foreign country of concern, as we just discussed in rulemaking. The penalties, in addition to our regular civil penalty and other penalties that we have in our toolbox, is for the official to have to repay the persons or entities double the value of the pecuniary benefit received. The commission could recommend that the statute be clarified to indicate the recipient of that repayment penalty, should you end up having a complaint related to that statute. Also, something that we have recently come across relates to the collection of automatic financial disclosure fines from university officials and employees. You have the ability through the Department of Financial Services and the CFO to have salary withheld from a Form 1 or Form 6 filer who fails to pay their financial disclosure fine. It's been a very helpful tool that the commission utilizes, and it appears that we do not have the authority to do that, to withhold from the salary of a university employee, because public universities are not actually any of the entities currently enumerated in the statute. Those entities are counties, municipalities, district school boards, and special districts. The commission could recommend that the legislature amend the statute to expressly include governing bodies of public universities. Okay, so with that, I'll turn it over to you. It kind of gives you the rundown of everything we've got. certainly you can have a fair amount of discussion on that today. We would love some direction as to whistleblower. If we are to be successful with that, coming as close as we did last year, there seems to be some political will. We do have upcoming elections, but the sooner we start working, the better. So I'll turn it over to you, Mr. Chair. Members of the commission.
Thank you, Director Stillman, and thank you, staff, for all the work that goes into preparing that legislative agenda and all the research that goes into it. We'll open it up the floor. Previously, what we've done is in July, have some open discussion. August, we give direction to staff of what we want to emphasize in the next legislative session. But open it up for discussion with respect to the items we identified for our 2026 recommendations, and if there's anything further we want to add beyond what we had proposed as our 2026 legislative items. One thing that I want to note with regards to the public records exemption, Director Stillman described some of the things that our staff go through, and in preparation for presenting the legislative agenda last year to the Senate, I would spend some time with Steve and Carrie discussing our investigators, our staff are the front line. They're going into sometimes hostile situations as investigators and having to do it in a very private way of respecting the confidentiality of the process. And our staff that are answering questions and individuals showing up to the office, they are on the front line. They're having to deal with many threats. Some of the threats that Ms. Stillman did not even mention today at personal homes, personal phone calls, that doing their public service. And I think the public records exemption, as someone who has represented press in 119 requests, I understand the open records law very much and the importance of having an open records law, but the safety of our investigators and staff and commissioners to a degree as well is important in order to ensure the public trust and ensure that the investigations are thoroughly done and that all the work that our staff puts into those efforts are protected. So that is the one item on here that I would really encourage us to pursue further next year. And with that, I'll turn it on to any other members that would like to discuss the legislative agenda further today.
Chair, I have a question for the team maybe about that. It would be nice for us to be included in that exemption, but I care more deeply that the staff is protected. I think that is really important. And I wonder in your conversations with the legislature, if it would be more likely to pass if we were removed from that request and it was applied to staff only. I just think the team is the most important thing. So I have a question about that. And then I will just say broadly, I am in favor of a more limited scope. I think the more things we have on the agenda, the more likely things don't make it through. And if the whistle, like last year we had some success, but the more things we have on the agenda, the more likely something is to get caught up. And so if there are one or two things that we find most important, like the public records exemption, I think that's important. I also would like to say that I think it's soon to start changing the law that was recently passed around hearsay. So that's my personal opinion. I think it's only been in play for 2 years. I know that there might be some challenges there, but I would not be in favor of amending that law at this time. Not that we should not continue to see how it inhibits or not our ability to do our jobs. But those are some initial thoughts. Mostly, I care about the staff.
Yeah, I concur with you, Commissioner Stewart, with personal knowledge other than hearsay statute. It's very recently changed, and I think we need to have more data points before going back to the legislature for revisions on that. I think let's see how this is playing out. It's staff works very hard, particularly the legal team, pulling out their Earhart on evidence and the hearsay rules, and we appreciate that. And I think just giving it time before tackling that issue again, as it relates to if we would limit this public record exemption to just staff, do we think it would have a better chance of passing if we pull the commissioners out and just focus on staff?
We don't really know what might be the pleasure of the legislature with something like that. We certainly understand the sensitivity of doing public records exemptions. We can certainly ultimately limit it to that if that is the desire of the commission, or we can, take it to members and see what part of it they think would be most successful, and let the members of the legislature decide what that might look like. There was legislation last year. I think it only dealt with state public employees. I believe it would not have included members of the commission, but it also included far more people than just commission staff.
Who was a sponsor of Senate Bill 1546? Do we know?
Off the top of my head, Amelia, do you happen to remember 15?
If they were interested in sponsoring before, maybe that's an area of inquiry of if we do adopt that as one of our items of that person being open to it just being staff, or whether they know whether it would be more successful just being staff. Senator Rodriguez.
Yes.
Any further discussion? Commissioner Rogers.
Yeah, thanks, Mr. Chair. First, on the public records exemption, I'll say I have a public records exemption from my service in the military. I think you're right to have that be a discussion point, but I would lean towards having the commission be included in that exemption. For anyone who's not familiar with the process, like, we still have to file all of our financial disclosures. It doesn't affect that. This is just removing our personal home address and personal contact information. So I believe that provides enough for what we do. So I would recommend commissioners be included in that. Again, getting no personal benefit from it. I did have a question for staff and for you, Mr. Chair, on the timeline. I think I agree. We probably want to have this completely buttoned up, I would think, going into or ahead of committee week. Just wanted your thoughts on that, Mr. Chair, or from staff. I would see, like, by November or so, we want to, slap the table on it.
I think by our August meeting, we would have direction to staff of which items we would like to propose for the 2027 legislative session. I know staff with the whistleblower protection, I think sooner the better is my understanding, in order to have that one proceed a little bit more expedited, since that is the one issue from last year that got the most traction. Is that correct, Gary?
Yes, sir. I think it'd be really helpful that should, in particular, Senator Gates and Representative Maney want to take that up again, that if we are contacted at any point, we're able to give a full-throated yes to that on behalf of the commission, if that is your will. We want to be able to move alongside very quickly.
And I appreciate Commissioner Stewart's point of having maybe it's one or two items we push this year and really double down. Commissioner Gray, as a former member of the legislature, defer to you with your knowledge.
So I would say two things. One, we have an there's an electoral cycle, right? So we're not going to have new members. We're going to have new members. I think that's the most important point. So it's going to take a lot more educating. You're going to have a lot more folks who are going to just be learning where the bathroom is, where everything is in the process, right? So you have that. But that also within the time frame, means session's not coming till March. So you still have a little bit of time. But I don't think there's any issue on the substantive matter of the bill, the policy as it is. I agree. I think we should. I don't think there's going to be a concern. I don't think us being added on there is a concern there. I don't think there's anything that would drive that. It's probably just more of like, what was the timing? Where to get stuck last year, and just kind of asking our former champions what they think they needed to move it around. But in the grand scheme, I think you're right. One or two, because you have a lot of folks just learning the process and just becoming new members. And they're going to need a lot more like educating up on just everything in general. So to that point, if you can laser focus, it's going to be helpful.
It seems among the commissioners, we very much want to protect our staff. That the public records exemption is definitely one of the two items that we want to emphasize in this next session. Do we want to also keep pursuing the whistleblower protection that has gained traction in the past as well?
Mr. Chair, just a question. I mean, and I'd look to the staff, Carrie and Steve, for more feedback, but just reading the notes on each of them, it seems like those would be the two where we made the most headway. And, leading into, having new members, new senators, there's, being able to speak to that track record, I think would be helpful. If they feel like there's a shot at some of the others, would want to have maybe some of that feedback as we come into the August meeting. But to me, that also pushes, the other ideas probably further out, if at all, that we're going to get to some of those. I think some of these are too recent, like we talked about the hearsay and enhanced referrals. I've got some serious evidentiary concerns about doing anything with that any further anyways. So I think that's something I wouldn't be interested in. And if there's another sort of planning session where we can hear about some of the technical items that were kind of further down, I'd have some more technical questions about those, but I don't think they're going to drive, me wanting to push any of those further up to get in the way of these two. Like you say, I think they're important matters, public records and whistleblower items.
Thank you, Commissioner Webb.
Yeah.
Yes, Commissioner Turner.
You mentioned the hearsay, and I think that's very important. Hearsay is unreliable. It's inherently unreliable. Plus, the agency's cost will go up significantly because they'll be chasing a large number of cases that are not fruitful in the end. So I'm against that.
Thank you, Mr. Kerner. Mr. Sokowski?
As you take this home and go through it and, decide over the next few meetings what it is that you do and don't want to do. The one I think that the legal staff might benefit from, which is such a small change that we could lobby on this pretty easily, is the Form 10 one. I put this in the category as of being necessary to explain a little bit of what this is so that when you go home and think about it, what we're doing here is we get a lot of phone calls on the Attorney of the Day hotline, and your legal staff mans that phone to provide legal advice to public officers and public employees on how to maintain compliance with the Code of Ethics. There's a lot of forms to fill out. Sometimes people get confused. And the Form 10, what it says is that the Form 10 should be filed with your Form 1 or your Form 6, which made sense when those forms were paper and when some of them were filed locally. They're all filed with us now. They're not on paper. And the electronic system does not accommodate the taking of a Form 10, so people are confused as to what they should do. It's not as simple as just changing the form, because the statute is the thing that says that it must be filed with the Form 1 or the Form 6. So we can't engage in rulemaking. We don't have the authority until the statute changes. So, what we're advising people to do is more in terms of practical advice than what, strictly speaking, the statute says. We'd like to align those things quickly. And so it's just the taking out 6 words, I think, from the statute. It's not a complicated change. We had this as a repealer bill in the House because it was just removing language. It wasn't adding language. And so we think that one is very simple, won't require a lot of, I don't think you need to include that as one of your 2. I think that that's something small that we can do.
It is more of a, Mr. Sokowski, it's more of a technical change than anything, more in that category of technical corrections.
As you can tell, I feel strongly about it, but yeah. But you are correct.
I saw you walk into the dais. Well, it sounds like we've had a fruitful discussion on the legislative agenda and have kind of formation of an idea. Is there any item that you all want to address today, or we can officially approve what items we want to do at August, taking the memo that was provided you prior to the hearing and now having the background information to decide?
Mr. Chair?
Yes.
So I was going to propose that I believe the Form 10 update, like just bump it down to the first technical. It makes sense. It's so light. I would ask that staff consider what it would take. I know it would take funding to make that an electronic filing. I know right now our Form 6s and our Form 1s are electronic and other ones are not. So I would be interested in how we maybe get that longer term into a easier, more trackable way. But I think for these purposes, it makes absolute sense to bump it down. And then from my standpoint, I think agreeing that we want to narrow these, I would deprioritize the auto first time waiver, and I like the rest of what you suggested, Mr. Chair.
Anyone further that would like to make recommendations today or do them in August after further analysis?
Mr. Chair,
Yep.
August after further analysis, I think would be best.
Okay. I think we have a general sense of where we're heading, so it seems whistleblower and public records exemption seem to be the priorities, but we'll finalize that in August, and as well Form 10 as our main technical one we want to address in the next legislative session to make sure Mr. Zolkowski stays happy with us. With that, we will we'll bring this back up at our August hearing. Thank you, Ms. Stillman, for the presentation and all the background information, all the work that goes into all the details behind these proposals. The next item on our agenda is discussion of the legal sufficiency reviews and rules. We will now we'll now move to the discussion of the Commission's legal sufficiency review process. Staff supplied Rule 34-5-002 of the Florida Administrative Code in your materials for reference during our discussion. I will recognize Director Stillman to explain the current process.
Thank you, Mr. Chair. Currently, staff responds to thousands of letters and emails each year. However, there is a particular process for complaints that people file that are attached to the required CE Form 50. And what guides that process in our office is the rule that is in your materials. That process has changed a little bit since the law changed that imposed statutory timeframes on certain actions of the commission. So the first deadline we have to deal with, the major deadline, is the 30-day deadline that we have to order an investigation. But the clock starts ticking when that complaint is received. The day it is received, it is stamped. We stamp the Form 50 as received, and it gets assigned to a member of the legal staff to begin technical review. This review includes making sure there's a properly completed Form 50, that it's properly notarized, that there's a statement of facts, and that statement of facts gets the initial review to determine, among other things, whether the respondent appears to be a public officer or employee subject to the commission's jurisdiction, and whether there are actual allegations related to the ethics code. Complaints that are technically deficient, do not have allegations under the code, perhaps they allege sunshine law or public records violations, elections law, court proceedings. We see all kinds of allegations that come in. When they're technically deficient, they're returned to the complainant via a letter bearing my signature with a brief explanation of why the complaint is being returned. That explanation is informed by the technical review that the attorneys have started, which also starts to inform any kind of sufficiency review that they do. Those complaints that meet the technical requirements are then routed to our complaint coordinator, Millie. She's like our clerk of the court. So that usually happens by day 3. For her to log as an official complaint. I also look at them. They're assigned a complaint number. Then we have to transmit them by certified mail to the respondent and provide a copy confirming that transition or the transmittal to the complainant as well. That has to be done within 5 business days of receipt of the complaint. The attorneys, meanwhile, are working on their legal sufficiency analysis of the complaints that have been logged in. They work on those analyses. They provide them to our general counsel, Mr. Zolkowski, for his review. Ultimately, they cross my desk. Any orders to investigate, I have to sign within 30 days of receipt of the complaint, and complaints that are not sufficient will have an insufficiency drafted, and those are the items which you review. After Steve sees them and I sign off on them, they end up on an agenda for you to consider during a closed session meeting for your review and consideration. As a part of that sufficiency review, as you know, each allegation in the complaint, you might have one allegation in a complaint, you could have 10 allegations within a complaint. That determination is whether or not the allegation is based on personal knowledge or information other than hearsay, as well as whether the complaint, the particular allegation, is alleging a matter sufficiently to invoke the commission's jurisdiction. So complaints where an order to investigate is signed within that first 30 days are then assigned to an investigator. And then that 150-day investigative clock starts to tick. So that's just sort of an inside view. When I say we respond to thousands of pieces of correspondence, that is true. And I think this year we're on par to break all previous records of the numbers of complaints that have been filed with the commission. Almost doubling. I think last year we had more than 100 more than the year before. And I think this year we're already over 250 complaints at the halfway mark. Puts us on par for 500 in a year. I don't think we've seen that since maybe around 1985. I think we had over 300 or 400 complaints. 100 of those were filed by a single individual at one time. Regarding financial disclosure. So I'll leave it with, now you have the basis of the rule and sort of our practice in the office, and I'll turn it back over to the chair. Thank you.
Would any member wish to be recognized to speak regarding the legal sufficiency rule or review process?
Mr. Chair?
Yes.
Yeah, question
Commissioner
for
Rogers.
executive, thank you, Mr. Chair. Through Chair, question for Executive Director. I had sent some correspondence, we had some discussion, it was about this section.
Yes.
Mr. Chair, I would say from my standpoint, I've got some suggestions, and maybe I didn't get them in time for rulemaking, so we couldn't fully get there. So we're under the sunshine law. I can't call you guys up and say, what do you think about this? This is the only spot we're allowed to discuss some of this. I appreciate the timeline stuff, and that's something I may want staff to even walk me through a little bit more. My thoughts were make sure that if there's an action against someone, they're notified as soon as we can without violating any of the other statutory deadlines that staff has. I know there's several of them as dictated there. Consider review by either the chair or the board. I think we're mostly doing that, but I'd be interested in the board's thoughts and yours, Mr. Chair. And then my last question was around the hearsay. I still feel like there's an opening, and I don't know if Executive Director, we could get that language out that I put out to the board, or we have to wait till next meeting, but I just think there's some opportunities to still tighten that up. My concern is the public record. Florida has a very broad public records law, and I wouldn't want something that's put into an email or something that's anyone could write an email and make a public record by emailing anyone's state government, or whether it's between government workers or even someone in the public emailing a worker. So some of my suggestions were around tightening that up.
Do you want to,
Tightening up the use of public records with regard to the information other than hearsay, or specifically in the rule, the commission's ability to look at a public record during the sufficiency review. Sometimes we'll look at the minutes of a meeting if there is a public record that exists that clarifies something that's been alleged. We have used that at times when drafting an insufficiency rather than having to order an investigation on when there's a public record available.
Through the
Yes,
chair?
Commissioner Rogers.
Yep, thanks, Mr. Chair. More of the former, and I think, I didn't even bring my, some of the comments that I had sent electronically, but I think that addressed it more in that section.
Mr. Zukowski.
Yeah, I can speak on that a little bit. Executive Director Stillman is right. There are two different references to public records in the rule that we're reviewing here. The first one is in the last section of subsection 1 of Rule 34-5.002. And what that says that in order to make the determination around legal sufficiency, the executive director may request additional information from the complainant. That used to be something that we could do when we had more time, but with the 30-day timeline that is now been rendered effectively impossible. It remains in the rule, and it reflects your staff's optimism that maybe it could get done but it's not really possible as we stand right now. And then the rest of that sentence says, so we may request additional information from the complainant and may obtain information from public records. That use of the public records is, generally speaking, it's not to bring complaints in to be investigated. This is a thing that we are prompted to do when we recognize that a complaint is very obviously misstating or leaving out very obvious facts. For example, whether or not somebody does or doesn't own a particular property, we can go to the property appraiser's website. If the allegation is that the property was left off of a financial disclosure, we can look and see who owns it to figure out, oh, it's not owned by that particular person, and therefore this complaint is not legally sufficient because it doesn't actually state a claim that would satisfy all the elements of the violation. I had our staff look at this to see how often we're doing that, and when you review our legal sufficiency recommendations for dismissal, like at the end of our executive session, you saw that there's a large pile of them. You'll often see in those, there's a citation to a footnote where we're saying we use this this authority to review a public record, and that's in the middle of our dismissal order. We're dismissing the thing because of, in part, that information that we were able to find. We've done that just this year 19 times. We have cited to that particular section, which represents you heard Executive Director Stillman say we've logged about 250 complaints. So just a little less than 10% of the ones that we're reviewing, we're citing to that authority as part of our effort to dismiss the case, not to bring it in. So that's our kind of tightening of what it is that we're investigating here. The other reference to public records is kind of inherent in the personal knowledge or information other than hearsay part of the rule, which is subsection 2. This is a reference to the fact that we will not look at anything that we will not allow an allegation to proceed if it is based on information that, unless it is based on information that either is not hearsay, or if it's hearsay, that it be admissible under the Code of Evidence, or that it likely be admissible under the Code of Evidence. Those are references to a particular case. I could talk more about that case if you want, but one of the hearsay exceptions in the Code of Evidence is that certain public records, not all public records, and that's but certain public records are admissible under the Code of Evidence. There are requirements to that. These would be, and I left my Earhart's copy over there by accident, but I meant to take it up. But it's not a reference to Chapter 119, and it's not a reference to all public records, but a very select few where the agency has an obligation I think I've got it, an agency under the law to create the record, or the record reflects the day-to-day operation of the agency. So it wouldn't be like you had proposed potentially a situation where an email was created between two staff people, and now suddenly this is going to be the basis of an investigation. Unless there is some other hearsay exception applicable to that, the public records exception, I wouldn't expect would apply to a scenario such as that. So we wouldn't be worried about its public record status in that scenario. So those are the two ways that public records tend to come into this particular rule, and how we're applying them, and the care with which your staff is approaching those issues.
Mr. Zukowski, The language in the administrative code has there been any case law analyzing that language with regards to personal knowledge or information other than hearsay?
Like I referenced, Mr. Chair, there is a case that we held very tightly to when the personal knowledge or information other than hearsay law was passed. We looked up to see if there was any case law, how to interpret the new statute. The statute might have been new, but the language was not. The language that the complaint be based on personal knowledge or information other than hearsay of the complainant, that is adapted from something that the Florida Elections Commission has in its statute. And it says the same thing, that they are bound to investigate only those complaints that are based on personal knowledge or information other than hearsay of the complainant. And so there was a case, it was decided back in 2010, one of the litigants, one of the people who represented one of the litigants is in the room actually. But in that case, what the court found was that the reference to the fact that their complaint must be based on personal knowledge or information other than hearsay, hearsay was being used in its common language, using its common language and common understanding, and that the plain and ordinary sense of hearsay was just what the legislature was trying to do in using that plain and ordinary sense of hearsay is to rule out an item that is idle or unverified information, gossip, or rumor, which is what Commissioner Kerner was referencing earlier about the nature of hearsay. So what we did was we took what the court said here. The court said and it was adopting language that the ALJ had used when it was reviewing an ALJ order. It said that there was being a distinction made between hearsay that will never be admissible and hearsay that is admissible or will likely be admissible. And we use that language in our rule. Exactly. We took it from the case, we put it in our rule. The case even used an example of something that would likely be admissible as hearsay. You said, something that would likely be admissible, e.g. with the testimony of a records custodian, the campaign treasurer's report as provided in, and then it cites to the business records exemption, for example. We took that example and put that in our rule to signal to the world what it was that we were trying to do with the hearsay rule to demonstrate. We're holding tightly to this case and the interpretation in this case. We're not extending anywhere beyond where the interpretation that the 4th District Court of Appeal assigned to the meaning of personal knowledge or information other than hearsay.
Do any of the other commissioners have any other questions for Mr. Zukowski? I know we had one member of the public that wished to comment. Mr. Heron, did you still wish to speak? Please come to the dais and identify yourself for the record.
Mark Heron, here on behalf of myself as a citizen. Just to kind of let you guys know, even though you see me up here defending persons charged with ethics violations for the most part, I sat on the commission for 4 years. I was chairman for 1.5 years or so. And I was the person who the executive director mentioned that held most of the hearings on those 100+ complaints out of Palm Beach County, which was an adventure. But just briefly, I don't quite understand as I'm sitting here what the issue is with respect to legal sufficiency, other than if the commission could find a way to eliminate the personal information or information other than hearsay for the basis of ethics complaints, that would be of great benefit to the citizens of the state of Florida. Right now, people who actually investigate corruption or wrongdoing, or whatever we want to call it, are, for the most part, media representatives. Anything they write is going to be hearsay, is going to be inadmissible. And that's usually the best source of information because you're not going to get people who are involved in those activities to basically come forward and say, hey, there's a violation and I did it, or I participated in it. And the only reason that happens from time to time is there's a falling out between people. Again, I don't want to take much time. I just wanted to say that I would like to see the personal information or information other than hearsay eliminated from the statute and eliminated from the rules. So.
Thank you, Mr. Herron. Commissioner Rogers, sorry, you had to step out for a second. Did you have any follow-up, Mr. Zukowski's presentation?
No, I appreciate the breakdown.
Any further discussion or comments from the commission? Okay. Seeing none, we'll move on to the next item in our agenda. Is there any further action we need procedurally, Steve, with regards to the rule discussion?
Unless there's more that somebody wants to discuss.
Or direction, yeah, I just want to make sure I didn't cut anyone off in terms of this. Any other direction or any other comments from the commissioners that they want to take with regards to the rule discussion? Seeing none, we'll move on to the next item on our agenda, the consideration of the proposed 2027 meeting schedule. Next item for consideration is our 2027 meeting schedule. Executive Director Stillman, you are recognized.
Just briefly, commissioners, you've got the proposed schedule in your materials. Happy to answer any questions about that. We did keep a legislative update in the middle of session. We started that last year because, you know, when the legislature moves quickly, it moves quickly, and it's very helpful to be able to meet with you all during session, depending on when our meetings fall, to get additional guidance from you. That is a virtual meeting. The remainder would be here in Tallahassee in this room.
Thank you. Any members have any questions or concerns regarding the proposed meeting dates for 2027?
Mr. Chair?
Yes.
I think we're gonna basically adopt or propose recommendations to this schedule right now. If the board would be so inclined, I would ask that we take this up next meeting. I'm in the process of finalizing what is my military drill reserve schedule. Sometimes that requires traveling out of town on Friday. I just want to make sure I can work around these dates as much as possible and propose any changes by next meeting if I run into them.
Director Stillman, would that impact anything with our noticing or anything, since these are going to be starting in January?
It would not, but I would, if there are some dates, because there are additional internal deadlines and noticing requirements, if you'll let me know so that we can have a sense when you take this up next time, what those different deadlines might be.
Yeah.
Coach Rogers?
Mr. Chair, absolutely. We're finalizing those dates right now in the next week, so I should have them to you within a
Just
week or two.
in case anything moves, that way we'll know that.
We'll
we're able
table
to-
this to our August meeting, the adoption of the schedule for 2027. Commissioner Rogers, thank you for your continued service. Moving next to consideration of expenditures. Item 15 concerning commission expenditures. Executive Director Stillman.
Thank you, Mr. Chair. I don't have anything to add to what is in your materials. Briefly, my expenditure authority for new members, I have a $10,000 expenditure authority. And so our Westlaw contract exceeds that, as well as the building lease. I'll need to sign invoices. The amount of that is $104,671 this fiscal year. Significantly, we have our contract with the Office of Attorney General for our commission advocates, plural, of which we have one right now, but it accounts for 2 commission advocates, as well as their paralegal legal assistant. And those expenses, that's $473,540 for this fiscal year that we're currently in. I'd like to be able to execute that contract and pay those invoices. We also have another another contract with the Office of Attorney General that we use when we have other types of litigation, but we never know what that will be until it comes, so I'll bring those matters to you. We also have current ongoing litigation under the contract that I could need to pay regarding the Form 6 litigation that has been ongoing. That gets paid out of carry forward, but I would need your authorization to pay those invoices in 26 and 27. So I ask your approval.
Entertain a motion approving the request for expenditures by Executive Director Stillman.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
All those opposed? Ayes have it. The expenditure is approved. Moving on to reports, I have a quick report. Just want to recognize staff. Commissioner Webb and Commissioner Kerner were added, joining us late this week as new members of the commission, and staff moved very quickly in order to have all the computers, the materials, the signs in front of you, the nameplates, and how quickly the staff moved and were able to get Commissioner Kerner and Commissioner Webb up to speed in order to be full participants in today's meeting. We really appreciate. Also want to recognize Advocate Burns, who is moved on to a different career than being our advocate with Advocate Hadley. We appreciated his service to the commission during his time and as a previous attorney with the commission. So I just want to recognize kudos to those individuals and all their work, and we're happy to have Advocate Hadley still with us.
Very happy.
Executive Director Stillman.
Okay, for the only thing to add to my executive director's report is I'd like you to welcome Simon Ashley to the staff of the commission. He's a student, Florida State University, and recently joined our staff as a part-time clerk. So when you call the office, you might get to meet Simon, who's here watching what we do today. So welcome, Simon. We're really glad to have you. And then shall I go ahead with e-filing?
Yes.
Okay, so the July 1st deadline has come and gone for 39,064 non-judicial reporting individuals. As of close of business on July 1, our total compliance rate was at 84.5%, with others filing after hours. But fear not, since that time, many more have filed their disclosure form. As of yesterday afternoon, overall compliance was 94%, just about. We're at 93.1 for state form filers. Form 6 filers are up there in the 90s. So we are doing we're doing very well on compliance so far. We like to end up around, I mean, the goal is always 100%. We would love 100% of the folks to file, but we last year we were at 99%. I'd certainly like to see that. There's about 3,900 individuals who have yet to file, and I'm confident that many of those will do that. We start our gentle reminders and not so gentle reminders next week with outgoing calls being conducted by our call center, calling folks to let them know we really would like them to file before the September 1 grace period deadline, and they start to get fined. We really do not take any joy in finding individuals. We want everybody to file now. We also have a postcard campaign for folks who ignore email that they receive. We send them a postcard in the U.S. mail that comes to their mailbox, and that always seems to get individuals' attention. So we look forward to continued compliance, and we'll be close to that September deadline in August. So if you haven't filed your form yet and you're watching this meeting, please do so right away.
Thank you. Thank you for all the work of the call center and our staff with regards to ensuring all the answers to the questions with the forms and helping to facilitate getting them filed. I'll entertain a motion to adjourn our public session.
So moved.
I'll second.
All those in favor?
Aye.
All those opposed? Ayes have it. We are adjourned in our public section.